So it's been really an extraordinary effect. I think others we've quoted are correct that I can't recall, and I don't think anybody's aware of any previous situation where a book so not radically, but so dramatically changed uh, the thinking in an entire field of law, and
Other
not
than
just in the
being
U.S.
other than being a great idea, why why did the book have such immediate and long-lasting effect, do you think?
Well, I think I've actually written about this, but it's been a while. But I think there were um, a couple of reasons. First, with regard to the court, um, I think the book really made it quite clear to the Supreme Court and Supreme Court clerks and everybody else around them that the old way didn't make any sense. I mean, in a way, the indictment in the antitrust paradox, like the indictment in the Declaration of Independence, in that case of George III, was a very important element of it because it deconstructed any possible adherence to the old way of doing things, and as well as offering a new and a coherent way of doing things. Um, there was an interesting example of this very early on in the history of it all, um, in the Sylvania case in 1977. It concerned vertical restraint. The Sylvania made televisions, and they had a contract with a retail dealer saying you can sell them only from a particular address in San Francisco and nowhere else. And the retailer, after some deterioration of relations with the manufacturer, opened a second store at an unauthorized location and was cut off. And that had been treated as a per se violation of the antitrust law. Um, any sort of vertical restraint like that, resale price maintenance, territorial restrictions, customer restrictions, were all condemned per se unlawful, without regard to the rationale and whether it was really sensible or efficient. And that came up from the Ninth Circuit, of course, from San Francisco. And the Ninth Circuit simply defied the Supreme Court's learning. They've done that a lot since then as well, but in that instance, and said that the legislative intent, I'm quoting them, underlying the Sherman Act has as its goal the promotion of consumer welfare. And we decline blindly to condemn a business practice as illegal per se because it imposes a partial, though perhaps reasonable, limitation on intra-brand competition when there's a significant possibility the overall effect is to promote competition among brands. The Supreme Court took the case, reversed themselves, and adopted the Ninth Circuit's view based on the antitrust paradox. So the court was clearly ready and hungry for reform. So why the staying power? And I think it's because the rationale, the consumer welfare standard, had some very significant and almost immediate consequences for the world outside the court. Um, and I must say, first of all, that the Academy uniformly disagreed with your dad's interpretation of the legislative history. Some significantly disagreeing with it, others saying, well, that wasn't consumer welfare wasn't the only concern. Um, but there was virtually nobody in the Academy that embraced the thesis of the book insofar as it was based on the legislative history of the Sherman Act, which is a mess, I must say. One can look into it and find pieces of this and that. But the first thing I think for explaining its longevity is that it substantially ameliorated the uncertainty that had prevailed when courts were freely choosing among multiple incommensurable and even conflicting values. That was sort of captured even by one of the academic critics, Professor Grandy, who rejected his view, Bork's view of the legislative history, but went on to acknowledge that Bork's thesis provides a clear and cogent set of rules the courts can apply in antitrust cases, and no other view of antitrust accomplishes this task as well. Well, that's a tremendous insight. I mean, the fellow doesn't agree with the legislative history, but says this is the way to look at things if you want to have cogent set of rules. So that's very attractive to not just to business interests, but to consumer interests, and to the courts. I mean, having a coherent set of rules is extremely important when you see them. Secondly, it substantially narrowed the range of conduct that could come within the condemnation of the per se rule, and introduced the rule of reason into almost everything. A huge change in the jurisprudence of the Supreme Court. And then finally, and why is that valuable? Well, it exposes the fact that the per se condemnation was condemning as unlawful things that were in most cases actually favorable to consumers, or at least benign. Just on vertical restraints, there's a meta study suggesting that 85% of all the instances that have been studied of vertical restraint, 85% of them were either benign or pro-consumer. Now, 15% were not, so you don't want to have per se legality, okay?
Right.
But it really pays. And when the court made that change, the number of cases over a few years dropped from 1,600 to 800. Those cases where you couldn't actually prove anything dropped out. It was so much easier when you didn't have to prove anything. And then finally, I think it put a visible end to the malleability of the antitrust laws in the hands of the lower courts, who could invoke almost any value. There's a passage by Justice Learned Hand from the Second Circuit, one of the most revered circuit judges in our history. And he wrote, Congress intended the Sherman Act to achieve certain socio-political aims. And then quoting him, helplessness of the individual, the organization of industry in small units. And then finally says the Congress had delegated to the courts the duty of fixing the standard for each case. Now that is not a rule of law. That is a mess. It is simply a rule of, a regime of total discretion, which is bad not only for those who are regulated by it and for the economy, it's bad for the rule of law.